My name is Carl Pearson, and I have an important video to create for you. And this one is on the New York courts, which have, by what I call a judicial statute, but that's just a court rule, they have brought an end to the foreclosure fraud that is existing throughout the country, but they have brought an end to it in New York with the prospects that other states may pick it up and deal with this problem in the same way. But let me explain what this whole problem is. It's a little bit complicated, but it's important, and this is right at the forefront of foreclosure activity in America today. The background is that I'm first of all a mortgage foreclosure defense attorney, and I operate in any state, primarily in New York, but I go into any state and I deal with these problems of mortgage foreclosure of homeowners. And I'm very familiar, I follow this, I have a whole series of videos, and you can see these videos, and many of you have, by going to YouTube, or I have a list of them and links to them on my website, carlperson.com. I ran for Attorney General in this recent election, and I came in third. The newspapers and the other major media did not give me any play at all, no debates. The public was never told that I'm even a candidate, and I did fairly well in spite of that, but you can't win elections unless the newspapers will tell people, and the radio and television stations tell people that there's more than just the Republican and Democratic candidates. That election basically is a fraud when the press tells people that there aren't any additional candidates. What a fraud that was. Now, another background here is that there have been fraudulent foreclosures all over the country because of various things, such as the notes and mortgages having been sold to other people so that the people who own them aren't appearing in court. The people that possess the original of the note and mortgage are not appearing in court, but someone else is, masquerading that they have the right to do it. The people are signing affidavits without looking at the papers, which is a violation. It's perjury. It's swearing untruthfully, and they have they're not appearing before the notary. They're using robotic notary signatures, people located in other cities. The whole thing is a mess. The whole foreclosure situation in the country is a mess because we have very strict laws in every state, at least in the 23 judicial foreclosure states, relating to foreclosure. And in these 23 states, the law says what has to be done, and the banks have not been doing that. They've been taking shortcuts because of the tremendous volume involved. They have not been adhering to the law, and they've been certifying falsely under oath that they have been. So their attorneys and the banks and all of this that are bringing these actions are in deep trouble for a variety of reasons, and I'd like to spell out what this problem is so that you can see where you fit in. It goes back to at least as far as anyone whose property has not yet been sold. That's just a beginning. At least it goes back that far. So that if you've lost a foreclosure action because you have failed to defend and they haven't yet sold the property, you have some protection now, even though there has been a default on your part. And even if there's a sale, it may have been to the bank, and you may still have some protection. And you may have additional protection beyond for a wrongful foreclosure action. So there's a lot of things that can take place now, but let me tell you what the developments are. One development is that in New York, there's a mandatory conference before the foreclosure action proceeds in earnest, assuming there's a defense and that there's no default. The bank and the homeowner are required to get together before the judge or a conference part and try to settle the case, try to see if there is a mortgage loan modification agreement that the bank can grant in that case, so that the foreclosure action is stayed during this process of trying to see if the bank and the homeowner can get together, if the homeowner has enough income to support a modification agreement. So it takes a few months at times, maybe a year or two in some cases, to try to work that out. But that's important because it stops the litigation meanwhile, and the bank cannot get the property. It just extends the process. In New York, it's a 2.5-year process to go from action, the filing of the action, to the sale of the property. It's about 2.5 years now on the average, I read the other day. Now, a new development is, and the judges and bank lawyers are stating this openly, that in the event the bank fails to negotiate fairly with that loan modification process that's in the courts, you have a defense of a bad faith negotiations, which is a further defense to the foreclosure action, so that if the bank doesn't negotiate in good faith, they may still not have a right to proceed with the foreclosure. So it's very important. This is a new evolving defense. I've always included that, meaning that they have acted in bad faith prior to bringing the suit, that they did not grant a modification agreement when requested. But now the court is applying that concept to the negotiations that are now required in court. It's a very important concept. I haven't heard this before, but they're now agreeing basically that there is or seems to be that defense, and they're willing to entertain it, which is very interesting. Now, the big development, though, which has precipitated this video, is that on October 20th this year, just about a month ago, less than a month ago, the New York State administrative judge for all of the courts in New York State, with the approval and probably at the direction of the chief judge of all of the courts of New York State and the presiding justice of each of the 4 appellate divisions in New York State, has promulgated a rule, an order, which is staggering with its implications. And this order, I just might show you very quickly what the administrative order is. This is the order, and this is the form of affidavit that accompanies the order. And the order says that the bank, in order to continue with its foreclosure action, for any part of a foreclosure process that's still before the courts, the bank has to, the bank's attorney has to file an affirmation, which is an affidavit that an attorney signs, not before a notary, attesting to the fact that the bank has reviewed the documents and that the proper notary activity has taken place, and that the various fraudulent transactions that have been occurring did not occur in this particular foreclosure. If the lawyer signs that affidavit, and if it's untrue, the consequences could very well be that the lawyer will be disbarred. Because there has been so much fraud going on, we have millions of instances throughout the country, I am sure, where lawyers would be not inclined at all to sign such an affidavit for fear that it would be held that they are swearing falsely, and that it could have severe ramifications. The lawyer could be disbarred, theoretically could be put in jail for fraud, and the net result is that in New York they won't allow the existing foreclosure action to go forward anymore unless the lawyer signs that affidavit and files it. And one court has already held that no, this has to be done every time the bank goes into court. You have to file sort of an update and let the court know that nothing has changed meanwhile. So with all of that pressure on the attorneys now, who have in some instances or many instances have failed to abide by the rules, the courts are preventing the foreclosure from going forward, and that means what? What's the consequence of that? The consequence is that the bank has got to enter into a modification agreement in order to stop the foreclosure, make the property performing once again. And they can only do that really, realistically, by giving a reasonable modification agreement. And that's what we're trying to get the administration to do, but they haven't done it. They've gone the other way of wanting to kick people off the property. New York has now taken the lead in this country, and the court has said that in a press release on October 20th that they are the first court in the country to do anything like this. Now, interestingly enough, I was running for Attorney General, and on October 10th, I put a press release on my website, my candidacy for Attorney General, a statewide position. And in this press release, I suggested something similar to that, and that the consequence would be, if we started enforcing these rules, that the banks would have to enter into a modification agreement. I wanted to do something to force the banks into entering into a modification agreement. My feeling is that because it's political, and the Attorney General of New York, who I was seeking to succeed at the by-election, was running for and was elected as governor. And because he was and still is at this moment, the Attorney General for New York, it's not possible that my opposition is looking at my website. You would hope that they do. And if they got the idea from that, they certainly are talking with the judges. The top lawyer is probably talking with the top judges in the state, one of whom was running for re-election. So I think that I probably had something to do with this rule. I hope I did. And that was the purpose of my candidacy, by the way, in order to get new ideas out there and hope that they're adopted. So what I see happening now is that New York State, with a thunderous bang, is now taking care of the mortgage fraud foreclosure situation itself, not waiting for any statute, not waiting for Obama, not waiting even for the state legislature to do something, but they have taken it on themselves to do something, and it's fantastic. So I applaud them for what they've done, and I want every other state to do something about it. But one thing is, you have to help out here. I want you to contact your local newspaper, for one thing, and have them pick up a column I wrote on this. I'm now doing a weekly column, and I'm asking weekly newspapers to publish my column containing information like I'm giving you right now, but it's a weekly column. You can find that column on my website, and I have the new titles. But some of the titles, which I've already done, I've created these and they're on the website, is one of them, the first one, Creating Prosperity is Not a Proper Governmental Function. Meet Mr. Vig, who is destroying the economy. Why bank branches proliferate in a declining economy. Increasing home values by 20% in your area. So there's a lot of different things that I write about, but essentially it's making life better, more economical for you, and trying to get rid of the ways in which people are stealing your money. That's what the column is about. Call your weekly newspaper and ask them to print that column for everyone in the town to read. It's for free, by the way. I'm not charging. I want people to learn about this information. So you can do that. Secondly, try to get people in politics to have the states that are not the 23 judicial states to adopt the laws like New York, so that homeowners in those states will have the protection of the courts as we have in New York, so that you just can't have your property sold out from under you, as is what's happening in 60% of the foreclosures,